Richardson, civil rights attorney at McCune Law Group, getting into it once again, breaking it down, the law and common sense.
I have with me civil rights and trial attorney and law professor Joe Richardson standing by. And Joe, while we watch this seal and see if we get any movement from our camera, what do you think about this process? Within 2 hours, this jury came back on day one saying they were hopelessly deadlocked. But the judge sent them back again twice now after they've said they are deadlocked. Are there any issues? If there's a conviction, will that be an issue on appeal?
Well, it really depends, right? We'll have to know more about how the jury is actually coming out, of course, as it pertains to all of the different charges as well. So it is interesting and very powerful that on the prosecution's presentation, it really looked bad for the defendant, but his testimony seemed to be pretty compelling. And to get them deadlocked, of course, they would be sent back a couple of times after 2 hours. They say they're hopelessly deadlocked. Of course, the judge is going to send them back. So it'll be interesting because there's been more hours and more time, there's less likely to be a successful appeal because you can't say that the jury wasn't thoughtful. So we'll see what happens with it, but it is very interesting to see how it's shaping up.
Are you surprised, and we don't know the full details because they don't go on the record as much, especially when the jury is going back out to deliberate, but our understanding is that when the judge decided at least the second time to send them back to deliberations, that both the state and defense agreed. We've seen situations where, at least in some instances, the defense really wants to accept that mistrial. They'd rather push the judge to go ahead and say, yes, you're hung, we accept it, read the Allen charge, try one more time, but that's it. If there is this agreement every step of the way through this so far, are you surprised that the defense doesn't take a different position?
Not totally, because I think that at this point, they probably still both believe they can win. And so with that in mind, the defense feels like his testimony was very, very compelling, and maybe it doesn't get any better than that. And if the jury gets an opportunity to acquit him, maybe you want to give them that opportunity and run it out a bit. And so it doesn't surprise me in that regard.
So we're continuing to wait. Again, we got word that this courtroom is filling up with people, and it has been a situation where they do sometimes come back into that courtroom after the lunch break because there's a note. When there was the note the first time around, they actually got it before the lunch break started, and then we didn't hear about it until the lunch break was over. I want to talk about this 11-to-1 split that we heard about on day one. The jury apparently let the judge know, not only are we hopelessly deadlocked, but here's the breakdown. They didn't say where the breakdown is it majority for guilty, majority for not guilty, or what have you. But they did mention that there may be this one holdout. Are there some other avenues to deal with a holdout, especially when you have this finding of hopelessly deadlocked after 2.5 hours? That to me suggests someone is really digging in and not taking the time to deliberate.
Yeah, I mean, the best thing really is to keep talking. And I don't know how much there was in terms of questions surrounding specific testimony and those types of things. But when you are 11-to-1, by definition, you are close. We're not sure what they were close to, but that means that there's going to be, more suggested conversation. And depending on if there were related questions and things like this, then maybe there's an opportunity for the judge to further instruct, and those types of things. But it certainly is interesting that it's 11-to-1, and this person must be very, very determined in terms of where they are. But now, given that the jury room is filling back up, maybe this means something different. In that maybe they've gotten over the line, but it'd be interesting to see what they got over the line with, actually.
I'm wondering, Joe, if you've seen this happen. I've seen it a couple of times in different jurisdictions, not there in Connecticut, but where a juror has been bounced for not participating. And I feel like it's a slippery slope to determine if someone's just very convicted in their beliefs after looking at the evidence, or if they are actually violating their role as a juror in the situation. What do you think?
It's hard to know that they are violating their role unless they specifically say so, unless you have jury nullification where they are saying, despite the evidence, I'm not going to find this guy not guilty, or I'm going to do X or Y or whatever else, even if there's an admission that the evidence would suggest something else, right? Other than that, I don't know that you really know. Maybe this person is just very convicted, for whatever reason, and, I think that the defendant's testimony got them in the game where it made it a lot closer question than we thought it was going to be. And therefore, if someone is on one side of it as opposed to the other, it's not particularly unreasonable necessarily, just the fact that it's 11-1. They could be being just as thoughtful as the other 11 are. But unless they specifically say, I'm ignoring the law and ignoring the rules because I don't care about them, it's hard to know that that's exactly what you have and therefore some kind of grounds for appeal.
It is so tricky. And we know that judges want to be very careful. They don't want to do anything that unfairly influences the jury one way or the other. And some can say that even throwing them back in the fire too often can suggest that the judge is saying you have to reach a decision. I want to go back to day one when we got the first note from these jurors only 2 hours into their deliberation. Take a listen.
Note reads, we are hopelessly deadlocked, 11-1 on the charge of murder at count 1. I did receive a note from you regarding count 1 and the fact that you are deadlocked on count 1. Each of the 4 counts must be deliberated upon separately. If you would like to deliberate on counts 2, 3, and 4, and then return to count 1, that is fine. At this point, I simply suggest that you continue with your deliberations.
And she did that again the next day, Joe, and they said, hey, we've gone through 2, 3, and 4, and we're still deadlocked. And then she let them know you can get any testimony you want reread. And then hours later, they agreed to do that. What do judges have to be careful of in situations like this?
They have to just make sure that they don't look like they're trying to tip things one way or the other. They just have to be certain that they are as thoughtful as they can possibly be. If they've gone over everything and said so, then they have to really submit to that and say, okay, maybe we mistried.